Oyez, oyez, oyez. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Everyone here? Good afternoon, Mr. Weber. Good afternoon, Ms. Brab. How are you doing today?
Good afternoon, Justice. Just fine.
Let me go ahead. Can you see the timer there?
Yes, it's right in the middle of my screen.
Okay, perfect.
Yes.
What I'd like to do is right now to give you some instructions, but before I do that, I'd like to introduce to you, usually to my right would be Justice Lucelena Chapa. I don't know where she is in your screen. And to my left usually would be Justice Lori Valenzuela. And I'm Justice Patricia Alvarez. You have 20 minutes. The appellant has 20 minutes, the appellee has 20 minutes, and the appellant has 10 minutes to respond. I'm going to please ask you to stay within your allotted time. If by any chance any of the justices have a question that goes beyond your time, I will give the same amount of time to the other side, okay, so that you both have the same amount of time. If by any chance we have technical problems, and let's say that we lose the Zoom, I will stop the meeting and I will pause it for, the timer will be paused, and we will, I guess, recess within 15 minutes to see if any, within that time, if any technical problem can be fixed. And if not, you will get an email or a call from our clerk of the court, Mr. Michael Cruz. Okay, so with that said, are you ready, Ms. Brab?
Yes, Your Honor.
And before you start, Mr. Weber, you can go off the screen. That way we can just focus on Ms. Brab. And then when it's your turn, Ms. Brab will go off the screen.
Good. I'll do that now.
Thank you.
Perfect.
You may proceed, Ms. Brab.
Thank you. Good afternoon. May it please the court.
It does.
The trial court improperly denied Mr. Brandon Grable and the Grable law firm's motion to dismiss pursuant to the Texas Citizens Participation Act because, one, Mr. Grable and his firm met their movance burden under the act. Appellee's claims are based on and in response to Mr. Grable and his firm's exercise of the right to petition.
And I'm going to stop you, Ms. Brab, and I'm going to ask the timer to be stopped also. Okay, thank you. And the reason being is I did not call the cause number and the style of the case, and we really need that for the record. So here it goes. Cause number 042164CV, and that is Grable, Grimshaw, and Mora, PLLC, and Brandon Grable versus Christopher Weber. You may proceed now, and I will give the other side 5 minutes, and I apologize for that.
Oh, thank you. I'll continue. So, basically, where I had started was that the trial court improperly denied the motion to dismiss pursuant to the Texas Citizens Participation Act because, one, Mr. Grable and his law firm met their movance burden to demonstrate that appellee's claims were based on and in response to Mr. Grable and his firm's exercise of the right to petition. Two, appellee did not meet its movance burden, its non-movance burden under the act. Appellee did not and cannot establish a prima facie case for each essential element of the claims asserted. And three, regardless of whether appellee met its evidentiary burden, Mr. Grable and his firm established an affirmative defense. The attorney immunity doctrine completely bars appellee's claims. The motion to dismiss should have been granted. Before I dig into my argument, I like to just give you a quick summary of the course of events that bring us here today. In July of 2014, Ms. Linda Nealon engaged appellee to be her counsel to represent her in a dispute against her homeowners association. As of September 2018, the matter was still pending. That's over 4 years later. At that point, Ms. Nealon sought out, as Appellee acknowledges, she sought out different representation and she engaged Mr. Grable and his firm to be her successor counsel in the case. By the end of 2018, less than 3 months after substituting in as counsel, Mr. Grable settled Ms. Nealon's claim, pursuant to her wishes and to her satisfaction. In September 2020, Appellee filed the underlying lawsuit, asserting a tortious interference claim and alleging that the substitution of counsel and the settlement of Ms. Nealon's suit somehow prevented his recovery of attorney's fees that he might have recovered if litigation proceeded and if Ms. Nealon prevailed. Mr. Grable and his firm filed a motion to dismiss. The trial court denied the motion and this appeal followed. To move to my first point, the movement's burden. The TCPA is triggered here because Appellee's legal action is based on and in response to Mr. Grable and his firm's right to petition. The TCPA provides all the relevant definitions. The TCPA defines the exercise of the right to petition as, among other things, a communication in or pertaining to a judicial proceeding. And communication is separately defined as the making or submitting of a statement or document in any form or medium. The judicial proceeding in this case is Ms. Nealon's homeowners association suit. And the communications are those between Ms. Nealon and Ms. Grable regarding the ongoing litigation and the documents filed with the court to effectuate the substitution, finalize the settlement, and dismiss the case. The entire premise of Appellee's claims are based on these communications in and regarding a judicial proceeding.
But we have some exceptions. Let's talk about the exception.
Okay. Specifically what, Your Honor, which exception?
Well, the commercial speech exception.
Sure, Your Honor. I will say this, in the trial court, the appellee did not raise the commercial speech exception. It was never raised in the trial court. It's not in the record below. Mr. Grable and his firm would argue that he's waived that exemption. However, even if not, appellee's reliance on the commercial speech exemption is misplaced. In order to meet his burden to prove the commercial speech exemption, appellee must prove, one, that Mr. Grable was primarily engaged in the business of selling services. Two, that Mr. Grable made the statement or engaged in the conduct on which the claim is based. The statement or conduct at issue arose out of a commercial transaction involving the services. And four, the intended audience of the statement or conduct were actual or potential customers of Mr. Grable.
Okay, from these four elements, which ones do you concede and which ones are you arguing?
Mr. Grable readily admits that he's engaged in the business of selling services. And he readily admits that Ms. Nealon is an actual customer of those services. What we argue here is that there is no evidence of any commercial speech, of any statements or conduct regarding the commercial transaction. Nothing has been presented to this court. There's nothing presented by appellee here. Appellee instead has pointed to conduct after the transaction, namely the settlement of the suit, which is not part of that commercial transaction in engaging Ms. Nealon as a client. I'd like to.
So let me ask you this. So what you're saying is that you're arguing there was no speech, but you're not arguing there was no conduct. Or am I wrong?
No, I would say both. There is no speech or commercial conduct at issue here. Nothing has been presented. There is no evidence that Mr. Grable did anything regarding the commercial transaction when Ms. Nealon approached him to engage his services as an attorney, as successor counsel. To provide an example of what does show speech or conduct at issue that courts around the state have found do fall into the commercial speech exemption. A perfect example is Beggs v. Clark, Love, and Hudson. It's a case out of the Corpus Christi Court of Appeals that was decided in December of 2020. In that case, a law firm, Clark Love, sued another law firm, Beggs Landers, for tortious interference. After Beggs Landers began sending out unsolicited direct mail advertisements to Clark Love's current and former products liability clients, alleging that Clark Love, among other various acts of case mishandling, quote, negotiated small and puny settlements, end quote, for its clients. The Court of Appeals there affirmed the trial court's denial of Beggs Landers' motion to dismiss, holding that the advertisements providing the basis for the asserted claims were squarely within the commercial speech exemption. Here we have appellee proffering no evidence of any speech or conduct that occurred during that commercial transaction. He just points to afterwards, basically saying, Mr. Grable didn't handle the case the way I would have handled it, the way I wished it would have been handled. And the settlement, left me wanting for attorney's fees, some reason. Without any evidence of commercial speech, the commercial speech exception doesn't apply. So Mr. Grable and his firm, they did not solicit Ms. Nealon, she approached them. So to my first point, Mr. Grable and his firm met their movance burden and the commercial speech exception doesn't apply. So we move on to the second step, my second point, the non-movance burden. And here, to survive dismissal, appellee had to establish by clear and specific evidence a prima facie case for each essential element of the claims asserted. First, appellee acknowledged during the hearing that if the TCPA applied, he did not meet his evidentiary burden as he did not file a response to the motion to dismiss. And appellee did not respond to any of Mr. Grable and his firm's arguments to this court addressing the elements of appellee's claims and the lack of evidence there too. But even with this concession and the lack of response, appellee cannot meet his burden. The elements of tortious interference are: 1, the existence of a contract subject to interference; 2, the act of interference was willful and intentional; 3, such intentional act was the proximate cause of plaintiff's damages; and 4, actual damage and loss occurred. To begin, an attorney-client relationship is an at-will contractual relationship. And as this court stated in Hume v. Zuhl, going all the way back to 1938 and still good law today, quote, the client has the absolute right to discharge the attorney and terminate the relation at any time, even without cause, no matter how arbitrary his action may seem, end quote. Ms. Nealon had every right to seek new counsel, to essentially seek a second opinion. Here, appellee billed Ms. Nealon for his time as the litigation progressed. Now, appellee alleges that he did not seek payment for the entirety of his fees because he believed he would, quote, eventually get paid from the homeowners association's insurance carrier, end quote. But that choice was his alone. There was never a guarantee of success in this suit, let alone recovery of those fees from the opposing party. Just because an attorney believes he should prevail does not mean that he will. Appellee's likelihood of recovery was always speculative. Mr. Grable's representation of Ms. Nealon did not deprive appellee of any guaranteed fee recovery. Moreover, if appellee believed he was owed fees from Ms. Nealon for the work he performed, he always had the option of seeking that recovery from Ms. Nealon under a breach of contract or a quantum merit theory. With more than 4 years passing since the initiation of her homeowners association case, Ms. Nealon made the choice to change lawyers and reach a satisfactory resolution of her suit. Appellee did not put forth any evidence that Mr. Grable coerced or misled Ms. Nealon into abandoning appellee as their attorney. Merely agreeing to represent a client upon that client's request for new representation and resolving the case as she desired is no evidence that Grable willfully or intentionally interfered with appellee's contract with Ms. Nealon. If this were the law, clients would never be able to exercise their right to the representation of their choosing and obtain new counsel because every successor attorney would be committing tortious interference. This just cannot be so. Finally, all of appellee's complaints as to Mr. Grable's skill and experience as an attorney are unfounded and irrelevant. It is immaterial that appellee thinks Mr. Grable did a bad job or he should have handled the case in a different manner. Mr. Grable owed a fiduciary duty to his client, Miss Nealon, to handle the case as she wished, and she wished to resolve this suit, settle it, and be done. Appellee's complaints about how the case were handled, which were all through his petition and all through his briefing to this court, are truly those of a legal malpractice case. But as appellee himself acknowledged to the trial court, he does not have standing to bring that case. That would be Miss Nealon. But again, she's satisfied with the result. The case is over. Appellee did not meet its non-movance burden, and so the claim should be dismissed.
Well, let me ask you this. Assuming that the commercial speech exemption applies, how does that affect the applicability of your affirmative defense of attorney immunity, if it does at all?
If so, the three-step process essentially, we proper evidence to say that the TCPA applies, and provided that the court finds that it does, then it is appellee's burden to prove that the commercial speech exception applies. And if it does, then those claims fall out of the TCPA and denial is appropriate. So to my third point, the affirmative defense of attorney immunity. Regardless of whether appellee met its non-movance burden, the TCPA provides that if the movement is entitled to dismissal, if they can establish a valid affirmative defense as a matter of law. Here, the attorney immunity doctrine completely bars appellee's claims. In 2015, in Canty-Hanger v. Byrd, the Texas Supreme Court stated that attorney immunity is a comprehensive affirmative defense, protecting attorneys from liability to non-clients. The court explained that attorneys are wholly immune from civil liability to non-clients for actions taken in connection with representing the client in litigation. And just last month, in Haynes and Boone's v. NFTD, the Texas Supreme Court confirmed the broad reach of attorney immunity and directly held that attorney immunity applies to claims based on conduct outside the litigation context as well. This affirmative defense is truly all-encompassing, with the only exception concerning liability regarding whether the actions of the attorney are those that are not the kind that an attorney usually performs. The issue is the kind of conduct, not the quality of the conduct. Regardless of whether the attorney's conduct is labeled fraudulent or wrongful, as the Texas Supreme Court made clear, the attorney immunity defense applies so long as the conduct was part of the attorney's discharge of his duties to his client. Therefore, the application of the attorney immunity doctrine is fairly straightforward. The question is simply whether the conduct complained of by appellee is the type of conduct which attorneys usually engage. Here, Mr. Grable and his firm accepted a client, filed an entry of appearance, moved for withdrawal and substitution of counsel, worked with opposing counsel to reach an agreeable settlement on both sides. Mr. Grable and his firm diligently carried out their duties pursuant to their client's wishes and to her satisfaction. Mr. Grable and his firm were acting well within their scope of representation. And to return full circle to Yunkin v. Hines, which is a case out of the Texas Supreme Court that found that claims against an attorney fall within the Texas Citizens Participation Act. And the court found as well that the attorney immunity doctrine applied and the attorney was entitled to dismissal. Yunkin is on point and provides the answer in this case. Appellee's arguments and opposition are misplaced. First, appellee argued in his briefing that, quote, affirmative defenses are typically subject of summary judgment, not motions to dismiss, end quote. However, that affirmative defenses are often asserted in summary judgment motions does not preclude dismissal under the TCPA based on a valid affirmative defense. Indeed, the statutory language of section 27.005 specifically permits such grounds for dismissal. And finally, appellee argued that this appeal is improper and that this court lacks jurisdiction because, quote, appellants did not seek or receive permission from the trial court, end quote. But Texas Civil Practice and Remedies Code section 51.014 subsection A12 specifically permits interlocutory appeal from the denial of a motion to dismiss under the TCPA. In conclusion, a client's right to the representation of her choosing, including terminating representation by one attorney and then engaging the services of another, does not permit retribution aimed at the successor counsel. Mr. Grable and his firm carried out their fiduciary duties to their client. She is satisfied with the result. Mr. Grable and his firm met their burden to show that this legal action is based on and in response to the exercise of their right to petition in service to their client. And in addition to the absolute bar to appellee's claims under the attorney immunity doctrine, appellee did not, as he conceded at the hearing, and cannot establish a prima facie case for each essential element of his claims. The denial should be reversed and the claims dismissed. Thank you.
Justices, any questions? I have one. You mentioned that, let me go back to the exemption, the commercial speech exemption. Okay. When you went through the 4 elements, you mentioned that there was no evidence produced by Mr. Weber with respect to at least one of the elements, the one you did not concede on, correct?
Correct.
Okay. Is it your position that the pleadings are not sufficient evidence in this case? At least for purposes of this appeal?
No, Your Honor, I understand that when a court of appeals is reviewing denial of motion to dismiss under their Tcpa, you're specifically supposed to look at the pleadings and what's below. I would say that the—
Well, Ms. Brad, then why even mention that there was no response on file or in the record?
Just to inform that the only thing you have to look at is from the pleadings. There was no, like his original petition, there was no response to our motion to dismiss. But you
Okay,
are—
so then in essence, are you arguing that the pleadings are insufficient?
They are wholly insufficient. There is no evidence presented in there about any conduct or speech regarding the transaction of Ms. Nealon retaining Mr. Grable as her attorney. So,
Any
yeah.
other questions? Thank you very much. You will have 10 minutes for rebuttal.
All right, and you would like me to turn off my video?
Yes, that would make it so much easier for us because we can focus on one person.
Okay.
Thank you. And Mr. Weber, are you ready for us?
Yes, Your Honors.
You may proceed.
Thank you. May it please the court. If I might, I'd like to address the appellant's discussion of commercial speech and that there was no evidence presented. I would disagree with that, first of all. In my petition, it does reflect that after Mr. Grable took over the case from my office, he filed a grievance against me, and he also, which eventually was dismissed, and he also filed a malpractice action against me, which was dismissed 1 month after it was filed, before any discovery had taken place other than his deposition. I believe that that would be circumstantial evidence of the kinds of communications that he would have had with Ms. Nealon, our joint client. But that begs the other question that's critical here, and that is, what evidence could I have presented? Unlike the cases that have already gone before the courts of appeal, this one would be limited to, the other ones had to do with, for example, commercial speech, advertisements put on the television, advertisements put on the radio, direct marketing to potential clients who were patients of ocular surgeons or something like that. And so there's independent external evidence of these commercial communications. The only commercial speech that might have happened in this particular case would be commercial speech that I would not be entitled to have access to. It would have been the commercial speech that took place between Mr. Grable and Ms. Nealon, which would be subject to the attorney-client privilege. Neither one of them could ever disclose it to me if they chose not to. Further, under the TCPA, this motion to dismiss has to be brought within 60 days of the filing of the action. That's wholly insufficient time to have done any kind of research to be able to find such evidence if it existed, and if I could even get access to it. So,
Hey, may I ask you a question, Mr. Weber? When was
course.
the petition filed? Can you give me a date? I couldn't find it in the record.
the
Or can you
petition,
send it to me later? Yes.
of course, the petition in this case, I can find that very quickly.
I don't want you to take your time. If you can just send it to us later, I'd appreciate it.
Okay, I will certainly.
Thank you.
Could I send that to Mr. Cruz?
Yes, please.
All right, I will. So that's my argument as to the commercial speech element of this, that in this particular type of circumstance, where you have an attorney bringing suit against another attorney for poaching a case, there's no way that evidence could be presented as to what that speech was when it's just simply between an attorney and their client. It'd be protected by attorney-client privilege. Under that theory, no case like this could ever be brought, which I don't think is the intent of the TCPA. The other point I'd like to address is the point that appellant made about attorney immunity and how it should apply. Every case where attorney immunity has been applied deals with statements made to third parties or opposing counsel, or an actions taken with regard to those types of relationships. There's no case that says that attorney immunity applies to positions taken with regard to prior counsel. And that's what happened here. And there's a big difference in that. If I were to tell a lie to an opposing party, let's say in a deposition, in a mediation, that I think would be protected by attorney immunity. Because attorney immunity has grown in the last 30 years since I've been practicing law. It used to not cover that kind of thing. However, that's much different than an attorney taking a position with regard to prior counsel. And that's what happened in this case. And there's no case that addresses that particular issue. If that becomes the law, then no attorney could ever be the victim of actionable tortious interference. And the law journal articles demonstrate that there are circumstances when attorneys have the right to take over a case, and certainly clients have the right to switch attorneys, but how that attorney takes over the case is paramount. And the way it was done here was improper and prejudiced my law firm's rights. So there is circumstantial evidence of the types of commercial communication that would have taken place between Mr. Grable and Ms. Nealon, and that would be the circumstantial evidence is the filing of the grievance and the allegations that were made there, which is in my petition, and also the malpractice action and the allegations that were made there, which again is referred to in my petition. So there is evidence in the petition of those types of allegations, that type of circumstantial evidence. The other thing is, counsel for appellant, I think, is perhaps misstating our position with regard to the lack of jurisdiction with regard to a particular issue in the matter. And that is that while I fully believe that the Court of Appeals appropriately has taken jurisdiction over the appeal of the denial of the TCPA denial, where I don't think the court has jurisdiction is in the denial of the attorney immunity defense. Because
I was going to ask you, and that's why I asked that question before. Why?
Because there's nothing that authorizes an interlocutory appeal to be taken from that type of a claim. There is clearly statutory authority that allows for an interlocutory appeal to be taken to a denial of a TCPA defense. There's no dispute about that.
So if we rule on the Texas Participation Act, then in your favor, then that issue is irrelevant, correct?
I think it would be, because the attorney immunity defense it was denied as well. And I don't believe this court has jurisdiction to hear it because the trial court's permission to appeal was never obtained. There's no statutory authority that allows for the denial of a motion for dismissal based on attorney immunity to be taken up on an interlocutory basis.
Ms. Brab also brought up the issue of tortious interference. What is your position regarding that?
My position, I think, is probably best stated in the various law journal articles, particularly the one from 2005, the St. Mary's Law Review article. Quite honestly, when I first looked into this issue, I expected that what the law was going to be is that if an attorney takes over a case from another attorney on behalf of a client, because the client has the absolute right to change horses, so to speak, that's the end of the story. But I got curious. And so I looked into it a little bit and consulted the oracle known as Google and found that St. Mary's Law Journal article from 2005 and frankly was blown away. I did not expect that to be the law. But that article makes clear in types of arguments that are directly involved in this case that attorneys can't do what Mr. Grable did. Certainly they can take over another case, but there are right ways to do that. And there are ways to do that that results in an improper and unlawful tortious interference. And that's what was done in this case. And that's the basis of the lawsuit. I don't like the fact that I'm having to bring an action against a fellow member of the bar. That's not something that I relish doing. I certainly don't have any desire to continue that. Frankly, I find it distasteful. But a wrong was committed here that prevented me and my law firm from pursuing the legal fees. And frankly, and I'm not bringing a legal malpractice claim here. I'm not. The issues related to the things that
You would not have jurisdiction over that right now either.
Correct. I don't have standing to bring it, as has been stated in the pleadings and in the argument and in counsel's appellant's argument as well. Clearly, I don't have standing for that. But I do relate these deficiencies by way of the underlying facts. That's all they are, is underlying facts. The claim is only for one cause of action and one cause of action only, and that is tortious interference. The rest of the information is background information, if you will. So in that regard, when Mr. Grable took over the case, he was unaware of a Texas Supreme Court case, or at least he didn't properly advocate it. It's the Tarr decision. In the Tarr decision, the Texas Supreme Court said that homeowners associations cannot extrapolate on the language contained in restrictive covenants when enforcing those restrictive covenants. It had to do with other issues, but the reason that was critical in Ms. Nealon's case is Ms. Nealon put a blue roof on her house. There was nothing in her covenants that regarded the color of the roof at all. It regarded materials that could be used, and one of those materials that was specifically allowed was standing seam metal. Ms. Nealon's roof was a blue standing seam metal roof. What I would have argued, and I believe successfully, was that because the covenants did not say anything about color, because they were silent on that, that so long as you use an approved material, you could put whatever color you wanted on it. And I believe under the Supreme Court's decision in Tarr, that would have to have carried a significant sway with the trial court. I anticipated being able to use that in argument with opposing counsel, the defense lawyers for the homeowners association. After all, it was brand new Supreme Court law. It came out right about a month after I was removed from the case. And Mr. Grable didn't make use of it. His failure to make use of it, again, I'm not complaining from a malpractice perspective about this, but his failure to make use of it prejudiced not only the client ultimately, but it also prejudiced my law firm's ability to collect the fees that were generated in making that case for Ms. Nealon.
How was that?
Had I been able to argue the Tarr decision either before the trial court in a summary judgment or just simply in negotiations or mediation with defense counsel for the HOA, I would be able to say, you know, that issue that we've been wrestling with for the last 4 years, I can't get we finally have a resolution to that issue. And here it is. The Supreme Court says you can't extrapolate. You're trying to extrapolate because the covenants don't allow anything about color, so we win. It would be that simple. And that reminds me, the 4-year issue. Normally, a plaintiff is better off in pursuing a case as quickly as possible. That's the general rule. But we all know as lawyers that for every general rule, there are often exceptions. And there's an exception that exists when I represent a plaintiff against their homeowners association for a covenant violation, alleged covenant violation action like this one. And that is, I'll just use Ms. Nealon's example. She put the blue roof on her house. She didn't have permission to do that. Yes, 4 years went by, but that was strategic delay. And the reason for that is because every day that goes by where there's no court order or no resolution regarding her or requiring her to remove that blue roof is another day she's won. Every day that goes by is another day that the people in the community see that blue roof on there and they begin to say, yeah, that, you know, that kind of does go with the neighborhood, or it doesn't strike us as unusual any longer. It's another opportunity. Every day that goes by is another opportunity for the composition of the board to change, which frequently happens in these neighborhood disputes. The board changes and the new board that comes on says, you know, I really don't understand why that prior board got so exercised over the blue roof. It looks just fine. So there's all kinds of reasons to delay cases from these types of cases. On top of that, right before we were going to go to trial, it turned out that the homeowners association's corporate status had expired and was not properly renewed. They couldn't go forward to trial. So it wasn't my fault that it didn't go to trial within whatever time frame appellant thinks was appropriate. It didn't go to trial because the homeowners association wasn't ready to proceed. Plus, there's the issue of that strategic delay that I talked about, which is unique, I think, to this homeowners association realm. So far from malingering the case or delaying it, that was intentional. And it was communicated with Ms. Nealon, and Ms. Nealon approved it. So the way I would have gotten those attorney's fees is 5.006 of the Texas Property Code says the party who brings and prevails in an action is entitled to recovery of attorney's fees. And every appellate case that has looked at that issue has told the trial court judge that's refused to grant attorney's fees, trial court judge, what part of the word shall do you not understand? Every case that has been sent back to the trial court has said 5.006 requires you to provide reasonable and necessary attorney's fees to the prevailing plaintiff who brings that action. And so that's why we would have gotten the attorney's fees out of the other side, to answer your question. Final point for why we would have done it is because the attorney's fees and this kind of thing, our firm generated a total of about $80,000. It was a hard fought case. It turns out that the attorneys representing the defendants, the defendant HOA, they spent over $200,000 in legal fees on that same case. So you can see how hard fought it was. My position would be, had we not matched them toe to toe, scrape to scrape, we would have been accused of being deficient in our advocacy. Yes, it got expensive. It's not the most expensive homeowners association case I've participated in. These cases get very expensive because you are being hit right where you live. And so people get exercised about it. I can address some of the other points I got, I suppose.
You got 4 minutes. I'll give you 5 minutes because of the interruption.
Thank you, Justice Alvarez. The types of things that Mr. Grable had alleged against me in the grievance, for example, that I'm sure must have been part of the discussion between him and Ms. Nealon that constituted that commercial speech, would have been that I had not communicated with Ms. Nealon. Well, I showed the grievance panel 400 plus emails between her and I. And then I also had proof of a number of telephone conferences that she and I had. And I had time records showing that she and her daughter and I had met in my office several times. So the fact that there was a failure to communicate was something that the grievance committee rapidly dismissed once they were presented with that evidence. And this thing about overcharging, he alleged in his grievance that I overcharged Ms. Nealon. I've already addressed that with the difference between how much we spent compared to the $200,000 that Austin Defense Counsel spent. But like I say, even after the grievance and even after its dismissal, Mr. Grable wasn't done. Then he filed the malpractice action against me. And I immediately took not Ms. Nealon's deposition, but his deposition. And the reason for that is because I knew that I could get him to admit what I suspected, which is that he had no experience in handling these types of cases. that, and that his attempting to do so was in violation of the state bar rules himself, that he would likely dismiss the case because he wouldn't want that to come to public knowledge. And that's exactly what happened. Within a matter of, I think, less than 72 hours after I took his deposition, we didn't even have the transcript yet. But within 72 hours after my taking his deposition, he dismissed the malpractice case against me. One more point I'd like to make for that, because I have a feeling that this may come back before this court again. And that is that in appellant's brief, they cite the Mary case, M-E-R-Y, which says that a counterclaim is required for malpractice, for legal fees in a malpractice case, or vice versa. Well, the case against me, I'd only had an answer on file for 30 days when it was dismissed, and it was dismissed without prejudice. In the Mary case, that case was dismissed with prejudice, which is why the complainants could not come back against Mr. Mary again. The dismissal of the malpractice case against me was without prejudice, which I think is a significant difference, because if I were to pursue the claim for unpaid attorney's fees against Ms. Nealon, and the limitations time is not expired for that yet, then I believe that the fact that there was a malpractice case brought against me and then dismissed wouldn't have any moment in that matter. With regard to, we've already been through the Texas Participation Act. That's that three-step process. The reason I didn't respond to it is the filing of a defense based on this act just simply didn't make sense to me. Everything that appellant has said about the act is true. It just has no application to this case. It wasn't something that was done in furtherance of the litigation. It was done to, I guess, somebody who Mr. Grable perceives as a competitor, somebody who he decided, like I say, to poach the case from. Had he contacted me beforehand and said, you know, Ms. Nealon has come to me, she's concerned about the time that it's taking. I agree that it's been taking a while. What's your theory on this? Why has it been taking so long? How do you expect to get your fees paid? All those kinds of things. We could have had that discussion, and then he could have made an educated decision about the type of assistance that he wished to provide to her. I offered to have that discussion with him, and he refused. I offered several times, he refused. As a result, he wasn't familiar with the TAR decision and its effect on this case, and how he could have gotten from, instead of having our client pay $3,000 to recovering tens of thousands of dollars. And so it's not so much that I'm complaining about what he did or didn't do. I'm complaining about the way he did it, which unfortunately is something I will never be able to get direct evidence of because of attorney-client immunity. And I see my time is up.
Thank you, Mr. Weber. Ms. Brab, you have 10 minutes.
Thank you, Your Honor. Can you hear me? Just want to make sure
Yes.
I'm back on. Okay.
Loud and clear. Let me pin you before you start. Okay, there we go. You may proceed.
Okay. Just want to address some of Appellee's points. Though he directly stated he knows this is not a legal malpractice claim, he then proceeded to go through what he thought were the deficiencies by Mr. Grable and his firm, and how he handled the case, and how he should have looked at this opinion. And that's all ignoring that Ms. Nealon is the master of her lawsuit, and Mr. Grable owed a fiduciary duty to her as his client, and she wanted the case resolved. At the end here, he was stating, as soon as Ms. Nealon approached Mr. Grable, he should have picked up the phone and called him to say, my client has concerns, what's going on? As soon as Ms. Nealon discussed in her initial consultation with Mr. Grable, confidentiality attaches. Essentially what Mr. Weber is hoping was that Mr. Nealon would break the confidentiality of his client who came to him to say, here's what's going on in my case, and I would like something done differently. That To ask that and hope that he had broken confidentiality to try and find a resolution is misguided. Let's see. Many of the statements that Appelli just made, I guess, it must have been. These are all suppositions. This is not evidence that anything egregious or nefarious occurred during the transaction when Ms. Nealon went to Mr. Grable to seek new representation. And his statement that no tortious interference claims could ever be brought because how can you break attorney-client privilege? Appelli himself, and even in that very lengthy law review article, cited various and sundry cases where there was evidence of egregious behavior. So when the facts and circumstances fit, Mr. Grable and his firm do not deny that a tortious interference claim could be brought. That's just not the facts here. And the grievance afterwards, I wrote down, said his grievance, his malpractice claim. The grievance was Ms. Nealon's. The malpractice claim was her claim. Her beliefs about how her case was handled. It's really not evidence of what Mr. Grable did. It's her thoughts about the 4 years of progression of this case and the non-resolution of the matter. Let's see. And just overall, the possibility of recovery of the fees is all speculative. I've heard, I read Appelli's briefing. I looked at the various cases. It's still all speculative. He believed he had a strong argument, but as he himself said, the homeowners association spent $200,000 on the other side. They must have believed they had a strong argument too. The courts are full of people on both sides believing that they're right. There's no guaranteed success. There was never any promise that he was going to get these fees. It all depended on if we filed this motion for summary judgment, if this came about during mediation or settlement talks. And also if the other side actually believed that that was a strong case and that was the path to resolution. Everything was so speculative and not guaranteed. Bringing suit against Mr. Grable to try and recover speculative fees based on what he's referred to as circumstantial evidence or things that happened after are simply not evidence of anything that occurred during that transaction, any nefarious action that occurred during the transaction. And I know he brought up his law review article, which is very lengthy, and I read through, and there's a lot of good information in here. It's basically an analysis of various, theories that could happen and ways to think about tortious interference claims. But at multiple points throughout the article, it raises these points that say courts that have specifically addressed interference with attorney-client relationships suggest that there must be particularly egregious conduct in order to support a finding of liability. This is because Texas and courts across the country hold sacrosanct the relationship between client and attorney. Clients and attorneys must be able to have a free discourse, and clients must be able to do what is essentially get a second opinion on a case without that attorney not feeling open and okay to provide honest advice on the possibility that it might lead to discharge of the previous attorney, hiring of a new attorney, and then opening themselves up for liability. As the law review article also stated, many of these cases say that as long as an attorney was acting in good faith, liability resulting from the discharge of the client's attorney and retaining new counsel should not attach. And finally, the statutory authority to hear this appeal regarding the affirmative defense. The Texas Civil Practice and Remedies Code specifically provides for interlocutory appeal for denial of special appearance. It doesn't carve out an exception saying if that denial, like what was argued, it just says the denial of a motion to dismiss under the Texas Citizens Participation Act is available for interlocutory appeal. This court has jurisdiction. Obviously, there are cases, Yunkin v. Hines is probably the prime example out of the Texas Supreme Court, in which the TCPA applied to the claims and the attorney immunity affirmative defense applied, and the claims were dismissed, reversing the denial from the trial court. That court, the Texas Supreme Court, believed it had jurisdiction to hear the appeal. You have jurisdiction to hear this appeal. In conclusion, the claims arise out of communications made in and regarding a judicial proceeding. The TCPA applies. Mr. Grable and his firm met their movance burden. Appellee has not met the non-movance burden, and regardless, the attorney immunity doctrine applies and the claim should be dismissed. Thank you very much for your time.
Before you leave, Justice Tcpa, do you have any questions? Justice Valenzuela?
I don't, thank you.
I don't have any questions either. I guess Mr. Weber can come back on. So we have everyone here. Okay.
That's Justice Alvarez.
Thank you very much for your arguments. Your case has been submitted and we will issue an opinion as soon as practicable. If you need a copy of this recording, please contact Mr. Cruz, our clerk of the court, and he will give you a copy of all of this. And we really appreciate it. It's a very interesting case to us, and we appreciate you coming through Zoom to argue your positions. And we are adjourned. Thank you.
Thank you for the opportunity. Justice Alvarez, I'm in the process now of sending you a copy of that petition you had requested.
Thank you very much. We appreciate that.
It'll go to Mr. Cruz.
Okay, we are adjourned. Thank you.
Thank you, counsel.